Right, good morning everyone. My name is Gavin Kelly, I'm the Executive Chair of the Resolution Foundation, and a warm welcome to this morning's event on a new deal for workers and what it means particularly for those in low earnings. I think I should probably also say a soggy welcome to autumn, given how wet I got on my way into work this morning. Hopefully it's not full-blown autumn for a bit. Now, today's event. Sometimes in the think tank business, you host events on issues which are a bit speculative, and you are hoping that you can sort of garner interest and relevance, and it's kind of a bit of a punt. Today is not one of those days. We're holding a discussion where I think the relevance is crystal clear. This is a really big set of issues that we're talking about in terms of new employment protection. It's an issue that there is lots of work going on in Whitehall as we speak. The government has set an overall clear direction. There was manifesto commitments, and there's going to be an employment bill appearing, I think, pretty soon. I think maybe some of our speakers will know more than I do about the exact timing. So it's a timely event, and we're not just talking to ourselves, which is always a good thing. We are talking to a much wider audience in a very real sense, in that when I looked at the attendance list for this event online as well as in the room, it was kind of full of people from relevant Whitehall departments, as well as from all employer groups and unions and many others. So it's an important issue. I'm talking about at the right time, and we've got great people among us. Now, in terms of what we're trying to do today, I think, put it very simply, we're trying to look at, very briefly, touch on some of the problems that we think the government's proposals are seeking to address. We'll do that quite briefly. We're then going to sort of try and explore what we know and what we don't know about some of the potential measures being put forward, and probe some of the potential benefits as well as some of the trade-offs and potential costs of those approaches. But I also hope that we kind of explore some of the unresolved issues and get a feel for some of the sort of the size of the gap, if you like, between some of the different parties, to get a sense of how bridgeable those issues may be. And in going about doing that, my sort of hope is that we can cut through some of the frothier, you might say, commentary that sometimes surrounds this issue. It's striking to me that when you talk about this topic, in general terms, quite often it incites quite sort of strong views, and people sort of say, oh, well, this is a lurch into the unknown, or a lurch back to the 70s, both of which can't really be true, I think. But when you actually get into specifics, then actually some of that kind of difference sort of melts away a bit. And yes, there are different points of view, of course, but actually some of the kind of big claims about how radical this all is, or how difficult it is, sometimes do fall away. Now, to see whether that's the view of the room and the view of the panel, we are joined by a great set of speakers who I'm going to introduce. We're going to hear first from my colleague Nye Comenetti. Nye's a principal economist at the Resolution Foundation and does a lot of our work on the labour market, which is core to what we do here. Nye has written a report, which I'm sure most of you have read. If you haven't, you will do soon. It's available online, and it's got a lot more detail than he's going to be able to give you in his short talk. So please do have a look. We're also going to hear from Delphine Strauss. Delphine is the economics correspondent at the FT, and you write a lot on employment, labour market issues as part of your brief. We're going to hear from Kate Shoesmith, who's the Deputy Chief Executive at the Recruitment and Employment Confederation, and has done lots of other interesting things before that, and is very involved in this debate. And we're going to hear from Michael Ford KC, who is a barrister at the Old Square Chambers, who, it doesn't say this in his CV, but is one of the country's top labour lawyers, employment lawyers, covering a lot of different aspects of employment law. And I said that Michael is also a Deputy High Court judge. So thank you to our panel. Really looking forward to what they have to say. After we've heard from them, we'll have a bit of a discussion amongst ourselves. We'll then open it up to questions. Slido.com is your friend if you are online and you want to ask a question. We'll have a mic in the room. We will try and squeeze in a poll for you to sort of tease out where you're coming from on some of these issues. And my job is to get us out the door by 10:45, which is going to be a challenge because you all have jobs to get back to, and so do we. So that is the lineup. I hope that makes sense. And I'm going to hand over straight to Nye.
Thank you very much, Gavin. All right, well, yeah, thank you for coming, everyone, and nice to see all of you, especially those of you that I've been seeing recently in some meetings, trying to figure out all of this and talk all of it through. So I hope we can have a good discussion today. Today I thought I would do three things. So first of all, set out the big picture on employment policy and insecurity in the UK labour market. Secondly, then, having taken a slightly closer look at four policy areas. So I think I heard yesterday that there are 75 different measures which the government is thinking about at some point or other. I'm just doing four, but I think I've chosen four of the bigger ones. So unfair dismissal, hours insecurity, statutory sick pay and the minimum wage. And then some thoughts at the end about some of the risks and trade-offs involved in embarking on this programme of reform. So I hope that sounds good. Okay, so first of all, the big picture. So this is one of those charts that gets built up slowly. So labour market insecurity can mean a number of different things, but traditionally, two of the things that I think are most important are one, how likely are you to lose your job? And to what extent does policy try to reduce the incidence of job loss? And we're measuring that on the x-axis. So this is from the OECD. They measure how strict are the regulations around making dismissals. And this is what I'm showing you on the x-axis there. The measure varies from 1 up to 3 or so. Don't worry, there will be some actual data arriving on this chart in a minute. On the y-axis, we've got what does policy do when you lose your job? So this is unemployment benefits, and it's how much of your earnings are replaced by those benefits if you go onto those benefits after losing your job. So I think these are two important dimensions of insecurity, but they're not the whole picture. So let's have a look at some countries. So you've got the USA down in the bottom left. So there's very little in the way of regulation getting in the way of dismissals happening, and benefits do very little at all to protect your earnings, to cushion the blow of losing your job. In the middle, sort of towards the top, you've got lots of European countries where job protections are a bit tougher, a bit stronger, and where the benefit system is doing more to cushion the blow of job loss. And then you've got some European countries on the far right who do quite a bit of both. Now, you might have noticed the UK isn't yet on this chart. Who wants to guess where the UK is? You don't have to shout out, because I will show you. So we're over there. So we're very much on the bottom left-hand side of this chart. So we're not the most extreme. We're not an American labour market. But definitely towards the lower end in terms of protections for jobs and also protections for workers, minimising the consequences of job loss. So I think overall it's fair to characterise the UK labour market as insecure, and you can, I think, underline that if you also point to the fact that we have many workers on 0-hours contracts and other workers facing hours insecurity, and also the fact that we have many workers who are in solo self-employment, so that they're not running a business, they are working for themselves, and those are features which are more prominent in the UK labour market than elsewhere. It is, I think, important to mention there is some good news here. So if you look at the timeline on the rate of people losing their jobs, actually that's coming down. So the rate of involuntary job losses has been trending down over the last 20 years, and that's good. And you can also see that workers say they're feeling less anxious about that than they were 20 years ago. So there is some good news there, but nevertheless, I think it is definitely fair to characterise the UK labour market as an insecure place where policy doesn't do a great deal to add security. Now, this context is important, I think, for helping us all to think, well, how big a set of changes are we really talking about here? The central thrust in the first couple of sections of my report is saying the UK is currently an abnormal country, and many of the reforms that we're talking about take us back towards normality compared to other countries. So on the blue cross there, I have moved the UK according to my best guess at what our overall dismissal protection measure would look like if unfair dismissal became a day one right. Now, that is only one of many other measures. I'm fully aware of that, but it's I think, one of the measures which is more contentious and which people are quite excited about. But I think hopefully this gives a sense that even though that would be a significant change, our overall regulation would be becoming more normal. We're not suddenly becoming a Dutch or a French labour market. And you might not want to be a Dutch or a French labour market because unemployment is a bit higher in France and the rate of hiring is a bit lower in the Netherlands. Okay, So that's the big picture on the labour market and what policy does in the UK. The reason this matters, particularly, I think, is because all of these types of insecurity, which I've already touched on, I haven't mentioned sick pay yet, but I'll be doing that in more detail in a minute. But all of these forms of insecurity, so how much pay do you get if you have to take a sickness absence? Do you face insecurity of hours? And how likely are you to lose your job during a downturn? All of these things are, low-paid workers are much more exposed than higher-paid workers. I won't read off all the numbers, but I think the chart makes that pretty clear. So overall, UK has insecurity in its labour market more than other countries, and it's low-paid workers that bear the brunt of that. So that's the sort of motivation for saying why, there definitely is justification for significant reform in this area. Okay, so now I'll do a bit more detail on those 4 areas that I've already mentioned. Starting with unfair dismissal. So this chart made me laugh, because sometimes you make a chart and it almost looks too silly to put in a report because some of the bits of data are so far away from some of the other bits of data. But I think visually it does quite a good job of underlining quite how different the UK's approach to unfair dismissal is to other countries. So what I'm actually showing you here is for how many months do you have to be in your job before you are entitled to protection against unfair dismissal. So you've got the UK in the blue line there. So you might first of all take away the fact that we have jumped around. We've gone from a year to 2 years at different times, but more or less in all periods, the UK's approach has been very different to that of most other rich countries. The exception is the USA, who don't have at the federal level an entitlement to protection against unfair dismissal, but all other countries, either Ireland or all of those ones that I'm showing you there in grey, which are all the European countries, Canada, Australia, and so on, they all have a much lower qualifying period. So you get this entitlement sooner into your job. So the UK is highly exceptional in this regard. So I think it's quite easy to say that this 2-year waiting period should come down, and we would be becoming a more normal country if it does. I think the really hard question is exactly how do you balance that trade-off around employers' incentive and willingness to hire people while giving workers that security. So the government's proposal is to make this a day one right. So they would take the blue line all the way down to the bottom of that chart. And so that would be a significant change. However, they have also said that they want employers to be able to continue operating probation periods. Now, as we go into in some detail in the report, it's not entirely clear what that means, because at the moment in UK employment law, probation periods essentially aren't a thing. They are important management tools for employers, and employers can add contractual entitlements and benefits at the end of a probation period. But in terms of statutory entitlements, probation periods don't appear. So the law will have to change in some way to make that work. And then the difficult decision for policymakers is exactly what kind of processes or requirements do you place on employers when they're making dismissals in that probation period? And that's the hard question. Our suggestion in the report is, because hiring rates, according to the evidence, look to be quite sensitive to this specific bit of policy, we suggest making that dismissal process fairly straightforward for employers within probation periods, and we suggest capping those at 6 months. I'm sure we can get into the detail of that in the discussion. Okay, moving along. Hours insecurity. This is slightly old data. It comes from 2017, but I think it remains the best way of illustrating the problem that this policy is trying to solve. So this is, by hourly pay quintile, what proportion of workers say they are anxious about unexpected changes in their hours of work. So first of all, you can see that this is an issue that affects low-paid workers more than it does high-paid workers. But I think the other important thing to note here is just the scale of those red bars. So we know that about 1 million workers in the UK are on zero-hours contracts, but I think this data helps us to see that problems of hours insecurity go beyond zero-hours contracts. In total, the number that say they are very anxious, so across all hourly pay quintiles, adds up to about 2 million workers or so. So zero-hours contracts is only really covering about half the scale of this problem. To be fair, the government's policy response to this doesn't, although it says we want to get rid of exploitative zero-hour contracts, the policy response, a right to a contract reflecting irregular hours, presumably would cover all of these workers. So I think that is a good thing. In terms of how this will work, the key questions we raise are, one, about eligibility for this new entitlement, and two, about what form this right would take. And really, because we think this is the most important problem that contracts like zero-hours contracts create that instability of hours and earnings from week to week. Eligibility has to apply to all workers, and the contract has to offer those hours as a guarantee every week. The reason, now that might sound exactly what you would expect, but I think it's relevant to raise those questions because in Ireland there was a similar set of reforms 5 years ago, and the right to a regular contract was a right that over the next 12 months your hours would on average fall into the same band that they had fallen over the past 12 months. Now that's good, it gives you greater confidence about your future earnings, but it doesn't solve that week-to-week volatility, which I think is so problematic. So those are our central points there. I've done a brief mention. There are some difficult questions about those businesses facing genuine, irregular demand. Maybe that's something to leave for discussion. Sick pay. So this is another build-up chart, but I won't leave you in suspense about where the UK is, but just to explain the axes first. So countries' statutory sick pay systems vary across many domains, who is eligible, how long the coverage lasts for, and a number of things. But I think arguably the two most important ways in which they vary are one, what is the level of the payment that you get and how much of your earnings do they replace when you go off sick, and two, how many days do you have to wait before you receive these payments? These are called waiting days. Okay, so in both these ways, a system can be more or less generous, and I've drawn some arrows there. So a system will offer more protection to workers if it offers a high rate of earnings replacement and if you don't have to wait multiple days to receive those payments. So these are OECD countries, and again, it's a similar story to that overall picture of labour market insecurity. The UK is kind of, to some extent, off on its own on this chart, again with the asterisk being that the USA isn't on this chart because they have no federal system of sick pay, and Korea as well. But of the countries that do have a system, you can see that the UK is over on the left-hand side there. In our statutory sick pay system, you have to wait 3 days while you get no payment, and then when you do, the level of sick pay is low, £116 a week, which is quite a bit lower than what you would get in a week on the minimum wage and much lower than what you would get on average pay. The other way in which our system is currently ungenerous is that you aren't eligible for statutory sick pay if you earn below £123 a week, which encompasses about 1 million workers. So what is the government going to do? It is going to get rid of waiting days, good news, and it's going to get rid of that earnings eligibility threshold, which I mentioned. Both of those things are absolutely welcome. They will extend coverage to many workers, and they will mean that if you have a short period of sickness absence, you will get some support, whereas at the moment you don't. However, I would argue it only partially solves this problem of insecurity in the sick pay system, and to really do so, you would have to have a higher level of statutory sick pay. And we go into detail in the report about what that might look like. Keeping on going. Minimum wage, I'll do this slightly more briefly. So really, the interesting thing here was the difference between the language in the manifesto and the election period and the actual policy as we've now seen it. So the government said it wanted to make the minimum wage a real, genuine living wage. The kind of obvious implication of that would be that it was raising the level to the real living wage. That isn't what is happening. It has asked the Low Pay Commission to consider the annual rate of inflation when it's recommending its minimum wage rates. I think, although there's definitely an asterisk here about exactly how the deliberations in the Low Pay Commission will work, but I think in practice that's not likely to make a big difference to the minimum wage level next year, over and above what the policy was under the previous government. And we would suggest that that is a missed opportunity. There's no reason yet in the evidence to give up on raising the bite of the minimum wage. But there is more happening on youth minimum wages, which we can come back to. And then, so those are all our 4 areas. I'll quickly do a bit on risks and trade-offs. So overall, you can think about a lot of this in the way that we have become used to thinking about the minimum wage. When you're raising terms and conditions of employment, that potentially poses an employment risk if employers aren't willing to hire workers at those improved terms and conditions. That includes higher pay, but it could also include these other things, like 0-hours contracts, more generous sick pay, and so on. Now that matters, and we need to take this seriously, in particular because many of these reforms will have a bigger impact on young workers than older workers, and we know that there are potential scarring effects to worry about here, and so on. And it's also only young workers where we've got lots of action happening on the minimum wage. However, we've had 25 years of practice at how to think about these problems of moving incrementally, taking the evidence seriously, and so I think these are risks, but we know how to deal with them. The more sort of tricky stuff are the specific risks and challenges that go along with some of the specific policy reforms. So I'm going to show you two here briefly. These are not reasons not to reform, but they are things that we need to consider when we're designing policy. So we're going back here to that regulation around dismissals, how strong it is, and I'm showing you two relationships across countries. One is the hiring rate, and two is the use of temporary contracts. And in both cases, there does look like there's a relationship across countries, and some of the literature does point to that as well. Now, as I said, that doesn't mean we shouldn't reform. It just means we need to sort of think a bit hard about exactly how we're designing policy to make sure we get all of the benefits and as few as the costs as possible. All right, sorry, that became a bit whistle stop, but I'll end there. Thank you very much.
Thank you very much, Nye. That was a formidable amount of material in not very long at all. I'm going to just hand straight over to you, Michael, to get your take.
Yeah, well, I'll carry on sitting down if that's right. Thank you very much, Gavin. Thank you for inviting me. I've long admired the Resolution Foundation publications, especially on enforcement. And thank you for your excellent paper, Nye. I just want to talk about three areas generally, mainly because there's not enough detail for me to focus on the sort of pedantic areas of law that I specialise in. First, the lack of any organising narrative. What we have is a list of disconnected ideas ranging from minor tinkering to major overhauls without much idea of what the underlying theme is. The second thing I want to talk about is the lack of detail. Although we know some of the aims, we don't know all, and we know very little about the means. And as many of us in labour law know, the means often matter more than the ends here, and it doesn't take those of us with very long memories to recall the unlamented statutory grievance procedure, for example, or other disasters such as the lamentable enforcement of many labour rights on the statute book. And the third thing I want to talk about, which really echoes what Nye's talked about, is what I call the leaky building of employment law. That is, you plug a gap in one part of employment law, it increases pressure elsewhere in the system, and a leak reappears in another part. I'm thinking of a flat I had in Bristol. And that's a particular problem if you're not looking at systemic effects. It's a particular problem when you've got a list of disconnected proposals, but you're not looking at the overall systemic effects, and I'll return to that at the end. So the first theme then, the lack of any organising framework. Well, we've now had the Green Paper, a New Deal for Working paper, then Labour's plans to make work pay, fleshing out the programme, and which, according to the manifesto, is going to be implemented, but not everything's in the King's Speech initially, and then the briefing notes to the King's Speech. All of these are very long lists, but they're all very short on detail. There seems to have been some sort of watering down from the New Deal, which was probably the most radical list, until we got to making work pay. Subtle changes in language. So instead of banning zero-hour contracts, we went to banning exploitative zero-hour contracts. Instead of scrapping qualifying periods, we, for unfair dismissal, went to qualifying periods plus probation periods. Fire and hire was no longer to be ended. There would be effective remedies and so on. But it's making work pay that feeds into the King's Speech, and it's a very long and detailed shopping list. I won't go through all the items. There's 11 in the employment bill, covering individual rights, some of those that Nye's touched on, trade union rights, family-friendly rights, not dismissing women, new mothers 6 months after they return to work, collective bargaining in the care sector, enforcement, and so on. Also, to the horror of many, don't forget we've also got proposals to introduce equal pay in the field of race and disability. Please don't speak to me about that. It produces heart problems. And then we're also having a consultation on single status of worker and a review of parental leave, all to be done in the first year. But it's hard to see any underlying linkage between these disparate ideas. You get talks of things like security and predictability, but that's about as much as we've got so far. And it's even harder to see an underlying linkage when you go back and look at all the things that aren't in the King's Speech, but in making work pay. For example, redundancy rights and TUPE, strengthened whistleblowing protection, new rights for self-employed, flexible working, right to paid carers leave, bereavement leave, switch off, fair tips, unpaid internship, strikes, repeal the 2016. I can go on, I'm only halfway through it. You get the picture that, and by the way, they've also got to pass legislation to address Mercer, where there's just been a declaration of incompatibility in relation to sanctioning strikers, which is very close to my heart. this is a breathtaking programme. I can't think of another piece of legislation in the past that covered so much. Perhaps the Industrial Relations Act 71 is the unhappy precedent. But it's very hard to see what the linkage is. The closest we get is the ugly term securonomics, which has unpleasant echoes for me of the EU term, if you remember, flexi security. So, and then we have talks, of course, of the virtuous circle of high pay, higher investment, boosted productivity and secure jobs. But there's very little of the sort of linkage you saw on past employment law reforms. For example, the vision that underpinned the Industrial Relations Act 71, or the vision of empowering employers and individual union members to resist trade union solidarity that underpinned the incremental Thatcher reforms. The closest analogue probably is the Blair government's Fairness at Work, which was something of a shopping list. But on the other hand, it still had very clear goals of employability and flexibility in a free labour market that wasn't overburdened with regulation. Compared to that publication, the existing ones we're seeing at the moment are very thin gruel indeed. And of course, Fairness of Work was a white paper. Now, I don't know, maybe someone in the room can tell us. What I've heard from others here is that there's not to be a white paper here. So we're not going to get the kind of detailed white paper discussing in the objectives that precedes the legislation. We're just going to get a bill and off we go. And that lack of an overall vision also makes it hard to know what some of the proposals are actually aiming to achieve. And here too, there's something of an unfavourable comparison with Fairness of Work, because we've got this list, but in many cases we don't know what they're actually aiming to do, which brings me on to the second theme, the lack of detail. Now, I'll have to be brief on this because the time is short, but even in those proposals where we do know, perhaps pause there. There's a first issue. Is Labour actually going to put in place everything in making work pay in one term? It seems to me a very, very ambitious programme. I can understand you get the 11 items in the King's Speech and in the Race and Disability Equality Bill, but everything in there, much of which will require primary legislation, it's a huge undertaking. But even in those areas where we do know what legislation is envisaged, there's an enormous amount of uncertainty. We don't know the precise policy goals or the means. Nye's already spoken about zero-hour contracts, reflecting the number of hours you workers regularly work. Is it only zero-hour contracts, or is it variable hour workers in general? Because many workers are on variable hours. You know, overtime or bonuses forms a huge part of their pay. Is the right automatic, or is it triggered by the worker? If so, does the worker have to apply to the tribunal if the employer doesn't agree to the trigger? What if the employer artificially reduces hours in the initial 12-week period? What are the regular hours just a minimum there? Is the worker required to work them? And so on and so forth. What about seasonal work, where you'll get dips across the year? What if the hours increase? Can the worker go back and re-trigger the right? These are just some of the problems. What's the remedy? These are some of the issues which I don't know, and I don't expect anyone in the room does, unless we have an insider here. And similarly with day one rights to parental leave, sick pay and unfair dismissal. Parental leave is easy because it's an 18-week qualifying period. It's an 18-week leave subject to a 1-year qualifying period. Easy, you abolish that. Sick pay, I don't know what they're talking about because there is no qualifying period. So do they mean something else? Do they mean that workers should have a right to contractual sick pay because there is no qualifying period for SSP? And then the big one, of course, unfair dismissal. At present, if an employer is to dismiss fairly under the primary legislation test in section 98, it must be for a specified reason, and they must act reasonably, which means in accordance with the standards that are within what's called the range of reasonable responses test. And tribunals have regard to the ACAS Code of Practice, which doesn't refer to probation periods. Of course, no doubt 2 years is too long. It's inconsistent with the periods the ILO has said you need to assess whether someone's competent, and it is longer than the initial period, which was just 6 months, interestingly enough, in the 71 Act. But what are you going to do about probationary periods? Is there going to be a different test of fairness for probationary periods? Are we going to ask the courts to start fashioning a period for probation periods? Will there be a maximum period of probation? Will the employer only be allowed to rely on it if it has a contractual probation period? What if there's no probation period? Hit the real horror story. What about those workers who are, and there are many, many of them, who in legal terms work on a series of micro contracts that work, as it were, have a week, then a 2-week gap, then work an hour, then have another gap. And there are millions of these in the labour market. I'm sure I'm exaggerating, but there are many of them in the labour market. What happens about them? How do you accommodate them? Because in legal terms, they have a micro contract and then they're dismissed. How does that work with probation periods? We don't know. And you can make similar points about things like the proposals on fire and hire. What does it mean to provide effective remedies? Are we going to see injunctive relief to cater for the sort of problem that arose in P&O ferries? Are caps on damages to be removed? You know, we wait and see. Are there to be criminal sanctions? What about unlawful to dismiss a new mother 6 months following her return to work? A completely new employment thing. I've got to hurry up. So that's that one. So quickly, last theme, the leaky building of employment law. And it's really echoing what Nye says. The lack of an overall vision here of the key principles and goals exacerbates this problem because no one's stepping back and looking at the systemic problem. And we start with the obvious problem of unfair dismissal protection. So we know at the moment it's employees only, not LIMB workers. If you protect employees from day one, the most obvious strategy for employers is going to be to try and ensure their labour force don't fall within the protected category at all. And there are tried and trusted methods of this. One is you can use agency workers, which the Resolution Foundation has written a lot on, because agency workers are not employees, so they're out. Secondly, you can use other forms of intermediary, and there are a bewildering range of these now in the labour market, such as personal service companies, meaning that the worker individually doesn't have a contract with the institution. The contract is between the company. So they're not an employee and they're not a worker. Or use other devices of the sort we've seen in Deliveroo, such as substitution clauses, which prevent someone being an employee and a worker. Now, the effect of these, of course, isn't just to take workers outside of unfair dismissal. The effect of those sorts of strategies is to stop people being an employee, which will mean they don't get the other rights for employees, like redundancy, like statutory sick pay, which are also part of Labour's programme to strengthen. Or the strategies can mean they're not even a worker, they're not an employee or a worker, in which case they lose everything. So a reform that plugs a gap in one leaky pipe produces a gushing geyser elsewhere, because the strategy to remedy it is to take people outside of protection altogether. And that really brings me in the full circle that, in a sense, fundamental to all of this stuff is worker status. If you don't address worker status and how intermediaries and other methods are used to take people outside of protections, which Labour says it will address, you risk undermining the whole edifice.
Thank you so much, Michael. That noise you can hear, by the way, in the distance is the kind of the civil servants who are drawing up the legislation, smacking their head on the table as they kind of add to their list of things that they have to grapple with in not very long period of time. We're not going to be able to do all of that justice, but I do want to we'll go around to other speakers and then we'll try and come back on a few of the points to unpick them a bit. I'm going to go straight over to you. Sorry, I should have clapped. That was brilliant. That was rude of me. So much material there. Thank you. Over to you, Kate.
Thank you. And I think if our employment and recruitment legal expert was sat in the room, she would be nodding furiously with a lot of the things that you've just said, having worked in this for, with a few footnotes, of course. And
more empirical work.
Well, one of the things would definitely be a mention of AWR and what that's done. I also wanted to talk about three specific things. I think first is coming to this conversation, and you know, every conversation with government and officials, is that it's not a case that there isn't a need for change. The labour market has fundamentally shifted over the last few years, 10 years, your analysis as you look back over what's happened. But actually the labour market is consistently changing. So what we see right now is a labour market that does not look like the one that we had pre-pandemic even. So and that's not just a direct result of the pandemic. Second is that whatever we do, it should be grounded not just in this understanding of what's the overall narrative and what's the direction of travel. How do we look at this in a systemic framework? I think that's like an excellent point that's really well made. But actually, what's the perspective of the individuals? So not coming at this from thinking about, well, what's in it for me or what's best for me. It's what do we really understand about why workers work in very different circumstances and quite different ways at the moment. And the third is that if you are to go about change, and coming from a perspective of saying that change is necessary, there needs to be the underpinning framework that allows that change to happen, and that starts with growth. So there's this big mission that we've heard from the new government, which is all about how do we enable growth. Where is that overall narrative, to take the point, that actually allows us to be able to afford an awful lot of these changes? So thinking about what's changed in the labour market, and we've already had quite a good list of this, but just if I look at it from my perspective, we can see the growth of platform working, we can see how the gig economy is now a big contributor. We know that there's legislation that requires change, and that's fundamental to the labour market. And just in very recent terms, you've already mentioned what happened. We were big supporters of getting rid of the legislation that came in to allow agency workers at one point to replace striking workers. That felt like a misstep. So that needed to be gone quite quickly. We need to think about fire and rehire practices, and we need that change. But we also need there to be a legal framework that allows for all of these different actors within the system, and the labour supply chain is fundamentally changed, grown, whether it is platforms, whether it is intermediaries like PSCs, whether it is umbrella organisations, that parity across, so that each of the engagers in work are faced with the same consequences, the same parameters for how work is organised, is really, really important. And actually, we don't know enough about where the labour market is now. Interesting that some of your data is your analysis, and that you referenced the 2017 survey. It's probably the best we've got to go on. I think the Workplace Employment Relations Survey, is it 2011, something like that? It's a long time. So what do we really know about where people are and how they're working and why they're working the way they are? And so on that, in terms of what do we know about individuals, well, on our own small scale way, we know that there are 1 million people on any given day who are working as an agency worker across the UK in multiple sectors. And so we commissioned recently Whitestone to do some independent polling for us to ask, why are these temporary agency workers doing this? And of course, what was very top of their list, they're saying they're doing it because they need the flexibility. And drilling into some of those case studies, we had amazing people telling us, from Jan, who was telling us about why she works this way because she was diagnosed with multiple sclerosis, and she had to take a step back from her very high-powered full-time permanent role, but she desperately still wants to contribute to the labour market. She's now doing it in a way that suits her. To an international student, Ikenna, who's working on his master's and made his own lobbying plea for us, if there are things to change in the labour market, please. For example, as it currently is, I can only do 20 hours of work as an international student, but I'd like to do more, and I can do more, and that would be really helpful to me. But I'm doing agency work because that's what's paying the bills right now, and he's managing that. To Claire, who's a locum radiographer, who fundamentally wants to be a clinician. She wants to be on the front line. She wants to do that job. She did not want to, after 18 years of working permanently in the NHS, wanted to be doing some of the management requirements from that. At the same time, she's running a training business. She's training the next generation of radiographers. So there's reasons that people are working this way. We need to really understand that. We need to get into that and not do anything that puts their lives and the consequences of their work at jeopardy. That's really, really important. And then my last point is around, well, how do we afford some of this change and this piece that is, where is the overarching growth strategy? So yes, we can talk about employment regulation. We can talk about how that can change. I think there is a really important point about how we get good quality regulation that comes out of white paper, consultation, the process that we go through, the number of different individuals that work on that. But speaking to businesses across the piece, they would say that when it comes to things like statutory sick pay or sick pay more generally or minimum wage, would you like to be able to offer more in order to attract talent, to be able to retain talent? What's one of your biggest issues as a business right now? Time and time again, labour and skill shortages come out on top. But how do they do that? How do they get to that place? And that's where you have to have some of these things that are being spoken about, but perhaps the detail still isn't there. And delving into, well, what does the industrial strategy look like? How are we supporting that? As well as allowing for the regulatory framework to sit underneath that to protect people in the right way. And I'll leave it there.
Brilliant. Thank you, Kate. I'm going to move straight on to Delphine.
Thanks, and thanks to Nye for a great report. Especially interesting to have the international context on all of this sort of quantified. I think we often have this kind of impressionistic sense that the UK is an outlier, sometimes a thing that business voices see as a big asset, but great to have it quantified. Also slightly terrified by your reminder, Michael, that it all hinges on worker status,
Yes.
given that that's probably the toughest problem out there. And apart from getting the growth to underpin it all, so small challenges there. It's a great time to be talking about all of this because we're obviously coming up to a real crunch point. We have this really firm promise to put forward draft legislation by mid-October. It's something Labour will very much need to deliver on against this backdrop of a very difficult situation for the public finances, difficult decisions coming up at the budget, and I suppose insofar as there is an overarching narrative for this package is that it's billed as the key way to tackle poverty and economic insecurity at zero cost to taxpayers. Lots of angst and worry among the people I talk to at the moment about the potential impact of the reforms, because there is still so little detail about what form they're going to take, and there are all of these issues about sequencing, which of the measures can be put into primary legislation straight away, which will need secondary legislation, which could be sort of thrashed out in codes of conduct at a later date. And that's before you get to the finer details about how to run a probationary period, or how you draft an in-house code of conduct on the right to disconnect, or any one of these 75 measures I was pointing us towards. All of these details matter enormously if this package is eventually going to make a real difference to workers while still being manageable on the employer side. So against that backdrop, I'd like to make three broad observations that I think corroborate very much what the rest of the speakers have been saying, and that come across really strongly when I speak to both workers and employers. The first is that the effect of these reforms really depends on the overall package, not just on the individual measures, because these things are interlocking ones. Just by way of illustration, I spoke to somebody earlier this summer who was at the sharp end of a lot of these issues. She'd just had some horrendous fight with her employer to get maternity pay. She was on a 0-hour contract where she'd been working for him for a decade, quite regular, long hours, but everybody was on 0-hour contracts. It was quite unclear whether or not she qualified for maternity pay. There's a qualifying period in which your hours are tracked. In the very last week of that period, her hours were suddenly put down to 0 for the first time ever. She had a very difficult fraught fight. She actually did get very effective help from HMRC and eventually won. By the time I spoke to her, she was working for a care provider, which was treating her correctly and was much more considerate, but still had a lot of restrictions on the shifts she could get and whether those suited her or not. So she was finding that she couldn't go for a job on promotion because they weren't able or willing to offer the flexibility she needed on hours. I don't think her position's that unusual. Spoken to plenty of other people who share sort of some or all of those characteristics. And what I found was interesting there was that she clearly would have been in a better position if zero-hour contracts were better regulated, or if she'd had this right to a contract reflecting her regular hours. But she would also have been in a much better position if she had, you know, the default right to flexible working, if there was better enforcement in the first place, and perhaps, you know, and perhaps she would benefit from the review of maternity and parental leave that Labour's promising. There were lots of different areas in which the overall package would benefit her. On the business side of things, I mean, I think for most businesses, the key concern is also about the overall impact of these measures, rather than one or other of the particular ones. You know, there are exceptions to that. I'm sure that, you know, if you're Amazon, you might be particularly concerned by greater union rights of access to workplaces. If you're a small business in the hospitality sector, zero-hour contracts will really matter. And, you know, there are other areas where it's a little bit more existential. But, I mean, speaking to one employment law advisor recently, the way he put it was that for a lot of businesses, these things are mostly a really big headache for the HR director rather than existential for the CEO. For the CEO, the big issue is just how much does the overall package create extra friction and cost? How much of that is there? And, you know, to what extent does that sort of then guide your hiring decisions? So that leads into the second point I'd like to make, which is that, you know, as everybody said, details really do matter. There's a very fine balance to strike for this package to genuinely make a difference to individuals without backfiring and having unintended consequences. And so, you know, I think the government's sort of promises that it wants a genuine consultation among both businesses and unions, you know, that's right. Everybody does have a shared interest in getting the details right here. I've spoken to sort of various people who are genuinely worried that tighter rules around zero-hour contracts could backfire if it leads to, you know, far more people being temps or lacking employment rights. Another example, as I sort of charted for, is early protection against unfair dismissal does seem to have a link to hiring and job mobility. And when one comes into sort of talking about probation periods, there are various people telling me that, you know, when it comes to cultural change, one slightly less welcome effect could be to make employers much less willing to give people a second chance if, you know, there are a few wobbles around performance in the early weeks or months, and they now feel they have a hard cut-off date where they sort of have to make a decision on performance. You know, one shouldn't overstate this. It's clear that 2 years is too long. There should be many areas where there's a way through these issues. And there are already plenty of campaign groups saying that, you know, measures have been watered down. Things are not going far enough on fire and rehire or on the right to disconnect. Which will, you know, probably take the form of strengthened codes of conduct rather than legislation. But, you know, as Nye says, you can't take it for granted here that things will go as relatively smoothly as they did with the sort of the gradual ramping up of the minimum wage. It's a far more abrupt change in a lot of areas at once. The third point, very briefly, which is always sort of comes up at events like this, enforcement's crucial. Enforcement of existing rights is patchy enough. I was quite struck by some research that the TUC published over the summer, showing that on any given day they can find, you know, quite some number of jobs, salaried jobs, sort of aimed at graduates and experienced people, advertised online, which don't seem to add up to the hourly minimum wage. there's plenty more to do there, and enforcing a whole swathe of new rights is a much bigger challenge. So seeing the detail of what powers and resources the new single enforcement body will have is going to be really crucial. I'm going to end there. There's obviously far more measures one could delve into, and far more detail in the report. I'll leave that to questions.
Okay, thank you so much, Delphine. Again, very insightful, and it reflects that you've been kind of working on this beat closely. Now, we're going to bring up a poll, just to, if we can, briefly, to get your sense of, because we're all saying lots of things matter and they all interconnect, but life is about priorities. So make your choice if we can bring this up. I think the question, if I can see it, which of the following workplace reforms will have the biggest impact on low earner security in the workplace? You can't say all of them, that isn't an option. And you can't say it's really complicated, they all interconnect. Let's just take your temperature on which of these, and I'm going to cheat and sort of, you've given us don't give us the result. This is the immediate. We're going to bring up the results in a bit, the final reflective results at the end. But that's just to see where you're at. Now, there's so much being put out there already for us to try and digest. I think, stepping right back, and I'm thinking about what kind of the sort of tenor of Nye's note, glass half full take is, I haven't heard much dissent from, the UK is quite unusual in terms of lack of security in various regards. Some of these proposals would, big caveat, if executed properly, and would take us towards being, reflecting more similarly some of our other kind of peer countries, which might not be that problematic. But it's really, really complicated. It's hard to do quickly, and these things all interconnect. And I think that feels in different ways, and that seems to be where people are at. Now, does anyone want to sort of pick a fight with that on the panel? That's a sort of start, because we're going to go into points of difference and points of nuance. But I think that's kind of, that's sort of in itself quite interesting. Now, obviously, that might just be who we've got the panel, but we've got people coming from different places and so on. So I think that is interesting. But in a way, I'm going to, this is for everyone, but I'm just do a few questions amongst ourselves while the audience kind of gathers a few of their own questions. I'm going to start with Michael, but others should come in. Now, I feel almost in the interest of balance, I sort of need to, I agree with so much of what you said and so many of your concerns and how these things interact and how complicated these things are and all the things you need to get right. That chimes. But a different take on what you're saying is sort of, government's really, really messy. Some of the example, I was involved, I'm old enough to be tangentially involved in the kind of Blair government's fairness at work sort of package. It didn't feel all that kind of coherent where you're in the middle of it. I think sometimes the coherence is a kind of retrospective thing rather than something which is kind of perfectly articulated by government of the day at the time. So I think, there's priorities and there's only so much legislative time and there's a huge amount of stuff to do and you have to make choices and you can't sort of always present a perfect systemic sort of approach towards an issue. You have to make some top choices. So I think we need to sort of put the kind of governing reality perspective on the table, as well as is it an ideal package? That would be my sort of one sort of gentle pushback, if you like. But the thing that really does, that came out of what you said, and Delphine sort of said this too, is that if you push hard or push, significantly one aspect of protection, then that can often have knock-on effects. I think the kind of single status kind of employment classification issue is a really, really important one. And you can definitely imagine pushing hard on sub-employment security and incentivizing employers to employ people and to use workers in different ways. Of course, the government has said it's got an agenda there, but that is just like really difficult stuff. I'm not saying it won't happen, and I'm actually very supportive of it. But it's really going to. That is not something you are about to do this autumn. That is going to take years to get right, and it will take lots of consultation. So I think one issue is this sequencing. Which doesn't mean to say you can't do anything until you've got everything right, because that's hopeless and you never do anything. But I think the issue of sequencing is really important, and understanding the scale of some of the risks of pushing hard on one thing before you're ready to act on another. I think that is that kind of. Does anyone disagree with that sort of judgment? No, we're all partly agreeing. Okay, well, let's try and make it a bit. Let's try and make it a bit more interesting. So, one of the key issues that we've touched on, that you've touched on, is this issue of probation when it comes to day one rights. And if you have concern if you think there might be a negative impact on hiring, and this is not, you can't prove this, but there's suggestive evidence that there might be some impact, then probation is the kind of go-to place. That doesn't exist in employment law statute at the moment as a category. Can you give us briefly, how big a deal would it be if, as part of this package, one of the ways that the government deals with different kind of pressures is to say, okay, there will be a probationary period that we will give some legal definition to. There will be some sort of different threshold, if you like, for dismissals within that time constraint period. I mean, when I say it like that, I think people might think, well, that's not that big a deal. You can sort that out. Is that how hard would that be to do? How long would that take, do you think, to get right?
Well, I'm sure you could do it, and I'm sure you could have a reduced standard. I'm not quite clear what it would be substantively or procedurally. You could say, you have to have a reason. That would be the lowest one you could possibly envisage. Because at the moment, under wrongful dismissal, you don't need any reason. You can dismiss someone and they turn up and you say, well, why have you dismissed me before the 2 years? And they say, I don't know, I just felt like it. Mind you, that's even a reason. So you could say it has some reason, and you could lay down utterly minimal procedure that you had to
going about it.
tell them before they were dismissed. You could do that. The thing is, though, as the procedure becomes more minimal, it almost looks like all you're really doing is saying we're reducing the qualifying period. So you could say it's 6 months, you just do something, you just tell someone the reason. That's the absolute minimum I can envisage. But even then, you've got to sort out the micro contract people, of which there are many, many millions in the labour market. What happens about them? Are they re-engaged each time? And then, so, of course, you can do this. But it's not just the devil in the detail. I suspect everything's in the detail.
Yeah.
And I think there is some analogue in the police of a feeling from the depths of my memory. There's something that applies to probationary constables, but don't quote me on that. You could do it, yeah. But how is the big issue? The means is the big issue.
When it comes to Kate in a second, is this an active conversation amongst labour law experts? Are people actually thinking about this, or are people just waiting to see what the government says?
Well, the stuff I've seen on there's a very good stuff. For example, Darren Newman writes a lot of this in his blog. He's saying, well, what do you mean? I think that's what labour law is.
Okay, that's where they're up
What
to.
do you mean?
Absolutely.
Can I ask, just in the interest of time, can I just move us on to another of Nye's issues, which is the right to a contract reflecting regular hours worked. And the paper sort of sets out both why that's an important change, given the sort of scale of insecurity that so many people feel, not just on zero contracts, but also some of the hard cases in terms of some of the sectors where there is really kind of intermittent demands, and there will be trade-offs. So that. How resolvable is that issue? But you're you're more involved in these conversations than many. They are going to do something in this space, and they've got a manifesto commit to do it, and there was a big problem which most of us are agreeing with.
Yes.
So what is the way through that, given that there are potential trade-offs?
Yeah. So first of all, what is the actual problems that we're looking to solve, and I think that also applies in the probation space as well. It's just what is it that's actually wrong here? And you had a really good example, Delphine, of what was wrong with a 0 hours contract where somebody was actually working in a very consistent way up until they were going on maternity leave. So what was actually going on there, to my mind, is, well, where does the enforcement of protections come in? Because that individual, you clearly had I would say, a bad actor in the system in terms of the employer who manipulated the rules, and that's bad for all employers that are actually abiding by the things that they want to do and how they want to treat their people and how they want to be seen as an employer and as a business. So there are areas where you should be thinking that shouldn't happen, because that's a misuse of the allowable rules there. And I think that there are absolutely businesses. This is the point of where are we all in terms of businesses around this. There's seasonal work, for instance, and it genuinely is seasonal. So if you take some of the areas of retail and hospitality, what happens in the run up to Christmas or in the summer season, what happens in terms of horticulture, particularly as you do the spring and summer and autumn harvesting, all of those things, they matter. And but
What are we going to do?
where we need to be is we need to be thinking about what are we actually trying to do. So in my world, agency workers have an awful lot of protections against some of these things already. So way back, when there was all the conversations about exclusivity of contracts and 0 hours contracts, it was already in the thing that we call the conduct regulations for employment agencies and employment businesses. It's on the agency to be finding work for that individual because that's how they get paid as the agency. So there's some things that are already in place. I think we need the analysis of what's already there that protects people the right way, and where are there the loopholes that are being exploited, and how do we cut down on those?
Okay, thank you. Delphine, I'm just going to ask you, you make the point, which completely resonates with my conversations with employers, that you often hear, particularly from thoughtful employers, it's not this particular proposal or that one, it's the kind of cumulative impact and the totality that I'm worried about, and that's what I want to talk about, which I understand. And then there's the real world of governing and politics. So how does that generic concern about the cumulative impact translate into a kind of negotiating position or set of, that has to come out in a discussion in Whitehall about something. So what are the where will that land? Will it be on day one rights? Will it be on or is it just like, can we do this all more slowly? Where do you think that pressure goes?
Well, I suppose actually one thing to say is that 0 hour contracts and hours more generally is probably the one area where people do feel most passionately about it, both on the individual side and on the business side. It's regularly the issue where we get hundreds and hundreds of comments under our stories, often giving really quite interesting details about sort of personal circumstances, both for small businesses and for people who've, it may be only 3% of the workforce, but it seems to be a very high percentage of people who have some experience of 0 hour contracts through a family member or previous job or whatever it is. And that obviously matters, really matters to people. So I think that will be sort of, the single area that's sort of going to take most thrashing out. It does also seem as if, yes, we have 75 proposals and then sort of possibly many more that were mentioned along the way in one document or another. There was obviously a very long sort of drafting and negotiation process before we got to the documents that were published in the run-up to the election. It seems as if there's a sort of core of measures that have to be thought about together, because they will impact one another around worker status, hours, these sort of core issues. And then there are various other measures that, for one group or another, would be nice to have, but you could imagine them being put back to a later date or possibly falling by the wayside.
Okay, so some things might be pushed away.
And I suppose I'm not as troubled as you are by the potential lack of coherence in the overall narrative.
Well, I take it as partly it is always historical distance, which allows you to see that.
Yes.
I take when you're in the thick of it, your point.
Yeah.
It's hard to see the themes.
Okay, so we're about to come to the room to see your questions, but I'm going to take one from online. In fact, I've had about 3 or 4 different versions of this question. So let's just, again, this also chimes, which is people from different perspectives sort of saying, well, there's a huge amount of legislative change, quite a few new rights being thrown at an enforcement and employment tribunal system, which, using different phrases, is on its knees as a basket case, etc., is not in a great state of fitness. What's going to if Michael, I'll start with you just briefly really briefly. Is that right? Can the existing employment tribunal and just general enforcement system bear the weight of these additional employment rights which may be coming their way?
Look, it's in a pretty bad state at the moment, and I'll be careful I don't accept some of my colleagues. But we know that the time to get before a tribunal is hugely long. We know there's a massive data, for example, the EHRC report onto pregnant women, enforcing their rights, all the resolution stuff on workers not enforcing their basic rights to holiday pay and so on. The massive evidence that emerged in the Unison case.
Yeah.
Yeah, I was going to say on the poll, if there's one thing that matters to all of this, it's enforcement. Because it's absolutely fundamental. And yeah, we need to, I mean, the single enforcement body is great, but again, we're a little unclear as to exactly what its powers would be.
Powers and resources.
I suspect we need something that goes beyond just enforcement by individual rights in an employment tribunal, because that model has proven to be pretty useless when it comes to the most vulnerable workers.
Okay.
They don't bring claims.
We're going to go. Have we got a microphone for questions? We do. So put your hand up. I say politely, we're looking for questions, not speeches, because we are up against it, and they're going to be impressively pithy. So I've got a gentleman in the yellow just there, yeah, and then another David behind him. I've got another gentleman over there. If we have someone who isn't a gentleman, we've got a lady over there. So we'll take this side first, and then we'll quickly come. Say very briefly who you are.
I'm Tim Sharp. I work at the TUC. We've sort of finally got, I guess, a period where, for the last 14 years, we haven't really, a government that's been very interested in employment rights, and we've got a government that's now sort of beginning to wrestle a lot of those issues around insecurity and people not knowing they've got a shift tomorrow and not being able to raise issues in the workplace. We sort of touched on a lot of the sort of challenges around detail, but there's also risks of this government enacting too slow.
Yep.
I think we saw that in New Zealand, for example. The government brought in sectoral collective bargaining effectively, but by the time they'd finished introducing it and they dealt with all the detail, they got kicked out, and the idea's dead in the water. So I was just interested whether, are there examples of labour, these sorts of labour law reforms that are actually being carried out very well. I don't know if it's too early to analyse what's going on in Australia, but it seems very familiar that a lot of the criticisms that might have been made now about coherence and too much too soon, we also heard, I think, made about Australian labour law reforms. So just are there examples where this could be carried out well that the current government could learn from?
Thank you, Tim. Good question. Just briefly on to David, who's just behind you.
Hi, I'm David Coates. I used to work for the TUC many, many years ago. Just to say, I think Michael's initial point about the absence of narrative or organising principle is right. You can say that pre-79, the organising principle was for labour law to support the voluntary system of collective bargaining. Post-79 to 97, it was all about controlling inflation by controlling unions. 97 to 2010, it was about maintaining labour market flexibility in a positive sense. 2010 to 2024, it was all about performative union bashing, I think. So if we were to have an organising principle today, what would it be? And what ought the priorities for labour law reform to be in the light of that?
Okay, thank you, David. I think there was a question, if you can self-organise, yeah? Tell us who you are.
Thank you. My name is Giovanni. I work at 5654, a corporate affairs agency in London. Okay. I wanted to ask you something about the timeline of the implementation of the Employment Rights Bill. We know that Angela Rayner said in August that this was going to be introduced before Parliament in October. This is something that Delphine repeated today. So I was wondering, what do you think is going to be effectively introduced before Parliament in October? Is it just draft regulations, or is it something else? Because we do personally expect some consultations to be thoroughly conducted before this is actually implemented.
Okay, thank you. Who was it? There was a lady over here. There's a lady. Oh, sorry, we're going to have to grab the mic. I'm going to just take it because of the time. I'm just going to actually take one long round, I'm afraid.
We need to see the poll results as well.
And we are going to bring the poll results up. Yeah, thank you.
Thank you. Laura Corrigan from Pearson. Actually, perfect question to follow on from, because it's just a bit of an extension. Have you got any insights into the timeline that we can expect for the development of this package of legislation beyond October? Mm-hmm. And what we can expect for the rest of the year and into next year as well?
Yeah.
Thank you.
Yeah, that's the tricky one. Okay. Any more? Any final? Before we go back to the panel? Last chance? No? Okay. I think I'll give, if you all just sort of have one go, if you like, rather than let's take them in turn, in the interest of people getting on with their mornings. Michael, I'll start with you. It'd be good to get both on the risks of moving too slowly. You kind of spoke about the fact that there's lots of complicated things you need to get right. But Tim's point is pertinent. There is a risk of moving too slowly and these things not actually ever happening. because there is a thing called the electoral cycle and other stuff. Like, how do you respond to that? And do you have any thoughts on the narrative point from David?
Yeah, Tim, I mean, I think you're right. Of course, there's a risk if you sit there and say, you know, we've got to have a perfect world, you end up doing nothing. But I do think it would help if perhaps we got more priorities. You know, what are the big ones here? Which maybe they are the individual ones that Nye's talked about, and some of the trade union ones. What are the big ones? And let's not get too worried about, maybe I'm being flippant here, things like the right to switch off, and so maybe some of those can be put back. So priorities would help. Yeah, there are examples internationally, which you probably know better than me. West Germany, for example, has protection against dismissing women who've just given birth. So that's an example. I don't know the organising principle. I just lobbing criticisms from the outside. I'm not sure what it would be, but you'd like to think it was something about rights effective in practice. I don't know the timelines, and I'm not sure which is going to be done in primary and which is going to be done in primary but allowing secondary, so sorry.
Sure, that's a hard one. Kate, anything on the time, or anything on any of that, but particularly on the timings issue?
Yeah, I think the thing we're all grappling with is there isn't a public timeline except for the commitment of 100 days. That takes you to mid-October. As far as I understand it, there's going to appear an employment rights bill around that sort of time, but there'll have to be consultation, follow-up secondary legislation underneath that, and yes, it'll have to be understood in terms of which areas they're looking into, and I feel like it's all still being discussed, because that's why you've got 75 different things that could be in it. When I think I was just straight after the general election, one number that was mentioned to me was 40. It got doubled very quickly. so I think maybe 5 have disappeared, and then I think there's a point about you're absolutely right about parliamentary terms and what do they do to the whole process, and why we should be able to step away from that and look at the bigger picture. And I just think about things like the Matthew Taylor review. You know, there's some core work there that could be used, and the organising principle for most of this surely should be coming back to, well, what is it that is the problem that we are looking to solve, and what do we understand about the labour market and where it's moved to that we need to protect?
I don't think anything came out of Taylor, did it? There was one thing, a change to the
in terms of
continuity of employment rules for some things, but other than that, it all went in the dustbin.
Exactly.
That lovely purple
So there's
book.
lots and lots of things in there. So yeah.
Over to you, Delphine. And is there? I mean, we can all agree that lots of things might take a lot of time. Is there anything that you can name that might be done quickly? I think that's in terms of this package. Mm-hmm. Or is it all just really complicated and going to take ages? Could anything happen quickly which would actually lead to an improvement in the UK workplace over the next 12 months or so? What do you think?
Well, I think the area that where it's clearly possible to act quickly is the repeal of some of the anti-union legislation, and that seems very likely to happen quickly. Not clear exactly what form it will take, and precisely what thresholds you set for balloting, precisely what the rules are will dictate the impact. But that seems the one area where we'll see something quite clear cut and early. Beyond that, we all wish we knew the timeline and the sequencing. That's very much seems to be the discussion that's underway at the moment. I suppose one thing that's come out quite clearly this morning is that there is a risk of doing some things quicker simply because it's slightly simpler and more possible to do them fast, while leaving till later some of the crucial bits that you might need if you're not going to spring a leak somewhere else in the labour market.
Yeah, that's kind of a summary of the dilemmas of governing and more generally, to be honest. But yeah, that's a good point. Nye, what's the narrative for all this? What should it be?
I mean, I wrote a 60-page report without saying anything as deep as underlying organising principles. I suppose the basic idea is there are lots of things that the UK labour market does well, but there are things that are very, very problematic. So you want to tackle the latter without losing the former, and without making the problems that we do have worse. So that's why I had all that stuff about trade-offs. But yeah, I think fundamentally there's been an acknowledgement for the past 10 years that we've got a problem of insecurity. Basically, everyone agrees with that to some extent or other, and now it's time to do something about it. I mean, that's not particularly deep idea, but I think that's.
There's something in that. Yeah. Right. We asked for priorities. Let's see what your priorities are. Can we bring up the answer to the poll? What did you vote for?
Oh, interesting.
Well, that is interesting. I think I would have been like enforcing rights would have been, but yeah, that's what you call a result. That stands out. Okay, that is, and just chime with what you were saying, Delphine. We are 2 minutes over. Could it be worse? Thanks to all of you who've joined us online. I know there's lots of you, and I'm really sorry I didn't get to go through more of your questions. Thanks to the great audience we've had in this room. We've got a busy schedule between now, particularly, and the budget. So watch out for more adverts of events coming up. We've got, I think, at least one per week between now and then. And join me, please, in thanking our brilliant panel. Thank you.